students. In this lecture, we are going to discuss very important topic of CPC as to when the foreign judgments will be operative as res judicata in India and will be binding on the Indian courts, and when it will not operate as res judicata in India. Okay, for this we are going to study section number 13 and 14 of the Code of Civil Procedure 1908, which enacts a rule of res judicata in case of foreign judgments. Now in this lecture, I will discuss with you section number 13 of CPC. Section number 13 of CPC is divided into two parts. In the first part of section number 13, it states about the general rule of private international law, in which it has been stated that foreign judgments shall be conclusive in nature. I want to repeat that the foreign judgments shall be conclusive in nature and will be enforceable by Indian courts between the same parties to the suit. Whereas the second part of section number 13 contains 6 exceptions under which the foreign judgments shall not be conclusive and will operate not as res judicata in the Indian courts. So, it is very important for us to know what is the meaning of foreign judgment. Foreign judgment has been defined under section 2 clause 6 of the code, according to which the judgment of a foreign court is known as foreign judgment. And what is the meaning of foreign court? Foreign court under section 2 clause 5 of the code means a court which is situated outside the territory of India and which is not established or not continued by the authority of the central government of India. So, if any American court gives a judgment, that judgment will be regarded as foreign judgment because American courts are situated outside India, first of all, and they are not established or continued by the authority of the central government of India. So it will be the foreign court. And if any judgment is given by that court, that judgment will be known as foreign judgment. Now discuss section number 13 of CPC. Section number 13 of CPC says when foreign judgments not conclusive. I already discussed with you that section number 13 of CPC is divided into two parts. The first part contains the general principle of law that foreign judgments shall be conclusive, it will be operative as res judicata between the same parties of the case. Whereas second part of section number 13 gives 6 exceptions under which the foreign judgments shall not be conclusive. The foreign judgments shall not operate as res judicata between the same parties of the case. What is stated in section number 13? Let us study. A foreign judgment shall be conclusive. It shall be conclusive as to any matter thereby directly adjudicated upon between the same parties or between parties under whom they or any of them claim litigating under the same title. So in the first part of section number 13, it has been stated that foreign judgment shall be conclusive. It will operative as res judicata on any matter which had been adjudicated by the foreign court between the same parties or between parties under whom they or any of them claim litigating under the same title. But when the foreign judgments shall not be conclusive, these are given in 6 exceptions of section number 13. The first exception says the foreign judgment shall not be conclusive where it has not been pronounced by a court of competent jurisdiction. It is very important that court must be competent to pronounce a judgment. If the court is not competent to pronounce a judgment, then the judgment of that court will not be binding in India. So, first point is where it has not been pronounced by a court of competent jurisdiction, it will not operative as res judicata in India. It will not be conclusive. Clause number B states where the foreign judgment has not been given on the merits of the case. When the judgment discuss no evidence of the parties, then in that time it is said that the judgment has been given not on the merits of the case. Where the judgment has not been given on the merits of the case, then the judgment shall not be conclusive in India. Or where the judgment appears on the face of the proceedings to be founded on an incorrect view of international law. When incorrect view of international law has been applied while deciding the case, then it will not be binding. Or there was a refusal to recognize the law of India. I want to repeat, there was a refusal to recognize the law of India in cases in which such law is applicable. Even then, the foreign judgment shall not be conclusive in India. Where the proceedings in which such foreign judgment was obtained are opposed to the natural justice, even then the foreign judgment shall not be conclusive in India. Or where it has been obtained by fraud on the court, even then the foreign judgment shall not be conclusive. It will not be binding on the Indian courts. And lastly, where it sustains a claim founded on a breach of any law which is in force in India, even then the foreign judgment shall not be conclusive in India. In the next videos, I will discuss each clause one by one. Thank you very much. If you like my channel, then subscribe my channel. And for notes, you can see my blog, which is lawarticle2020.blogspot.com. Thank you very much.